The new MUMS Act, Moving Ontario's More Safely Act, now includes a 14-day roadside impoundment when you are charged with your stunt driving or racing in Ontario under Section 172(1) of the Highway Traffic Act. This means that if you speed at 50 kilometers per hour or more above the posted speed limit in an 80 kilometer per hour or higher zone, or if you're 40 kilometers per hour in a zone lower than 80 kilometers per hour, you will immediately get your car impounded at the scene of the charge. So what happens now? Your car will be towed and your license will be suspended immediately. And you'll be left having to make your way to your destination by other means. And during this period, this is where our firm gets the most client calls because clients are frustrated and they're often panicked on how to get their car back after the 14 days and pay the crazy high impound fees. Now, don't blame the officer. The first instinct many people have is to analyze the officer and their behavior at the roadside. Were they cold? Were they helpful? Why didn't they lower the speed? Why didn't they show me the radar? I wasn't going the speed that they claimed I was going. At this point in your charge, none of this may be relevant. It might, but it may not. And in fact, we won't know the answer to this until we get the most important part of your charge given to us, which is called the disclosure, which is the evidence, which will detail all of the interactions for the speed, the radar that was documented at the roadside during your charge, etc. Now, the other question is, there was no way I was traveling at the speed the officer told me. Well, it's too early to know this because once you get that disclosure or the evidence, it should outline the radar type, if the radar was properly calibrated, if the officer checked the radar, etc. But there's little value to arguing this point even before the evidence is available. Now, although you may have a lot of questions and are understandably frustrated, the next step here is to wait until the disclosure is made available, which can take 4 to 6 weeks or longer. Well, another question is the officer never told me my exact speed and didn't want to write it or didn't write it on the summons or my ticket. Well, the officer at this point is not obligated to show you the radar or give you the details of the roadside. Many clients are frustrated by this and they want to argue this in court. But as stated above, this information is made available in the officer's disclosure, which comes at a later date. And this is where we can check if there are mistakes. And we can check the exact speed, we can check the exact location of the charge, etc. So be patient. Now, how do I arrange to get my car out of impound? That's a good question. You should have gotten a form or details about the impound lot from the officer, and you can call the impound or the MTO closer to the release date, and they will give you all of the details on how to get the car back. And generally, this is pretty straightforward, and you will get a date when you're eligible to get your car back for the impound. You will be required to pay that high impound fee and the car will be released back to you. So what are my next steps after I get my car back? Well, the 14-day impound and the roadside suspension is just the beginning. Now you have to deal with the actual charge of stunt driving in court. And a stunt driving conviction can have serious penalties such as a mandatory 1 to 3 year license suspension upon conviction, which was updated June 3rd, 2021 with the MUMS Act. It can have up to $10,000 in fine and up to 6 months in jail. These are the penalties that will impair your ability to work and drive. And these are the penalties that will have a serious impact on your civil liberties. These are the penalties that you need to be focused on. And these are the penalties that should be enough reason for you to get legal advice and a strategy that will help you keep driving in Ontario.